Hi everybody, this is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Comment Counsel. This is the show where we go over your comments and we talk about your comments for the last week or the last few days. So let's get into it. The first question is from S. Sadia Ben Fairs, and he or she says, how much is a complete avulsion of the hamstring tendon? How much could that be worth? That got fixed by surgery and a lot of therapy. Okay, so that's a good question. So number one, I'm thinking of a few things. Number one, I would have to do a verdict search to let you know how much it's worth. I would need to know where you are, because in some parts of the country, it might be worth, let's say, 500,000. But in other parts of the country, in a different venue, it might be worth 2.5 million, right? I learned that with fusions. For example, in the Bronx, in New York, fusions could be 2 million. But in a rural, conservative part of Virginia, somebody asked me, and I did a verdict search, and over there it was like 200,000, even 150. So that would be a critical factor. And the other thing is, remember, procedures alone do not necessarily have value, or maybe I'm saying it wrong. The right way to say it is like, I can't give you value from a procedure. So for example, one person with a complete avulsion fracture, a complete avulsion of the hamstring tendon with surgery, who doesn't have like any kind of human story, doesn't have any before and after witnesses, doesn't really testify well, just says, yeah, I had the procedure, what can't you do? Maybe I couldn't run. And that's all he says, right? He might only get like, 200,000, but somebody else who explains that, they used to coach their sons like softball or their sons little league. Now they can't do that. Now the son is upset, right? They have the son testify. They have coworkers testify. He used to, do something like go up and down the stairs at work. Now he can't do that. He's out of work. That's much more powerful. You have stories, you have moments in time, you have how the holidays were affected, right? Everything. So that particular case, the second case, maybe you'll get 5 million, right? Because the jurors will empathize and sympathize, right? And have compassion for you because they might have a son, they might have, of course, they have a coworker. They understand what it's like not to be able to work, not to be able to provide for their family, and you have themes that you explore, right? So that's why I can't tell you, just by telling me, hey, I have a herniated disc. Well, yeah, sure, one herniated disc could be worth 10 grand and another one could be worth 10 million, right? So the best thing to do if you really want to know is just to text me, right? 347-566-9595, because then I can do a deep dive. I could ask you questions, we could interact, and I could get a better understanding and give you a full attorney consult, and then I could tell you what it's really worth. Plus, I don't mind if you already have an attorney, I could do a verdict search on that attorney and tell you their past settlements, their past verdicts. And the same way I could do a verdict search on this complete avulsion fracture of a hamstring tendon, wherever you are. Maybe you're in Chicago or you're in Miami or you're in Los Angeles, I don't know. So I could tell you what the verdicts have been for your type of case too, because you might have a truck accident or a slip and fall. So that's always the best way to do it. Okay, and JPM33 16 hours ago asks, hi, what happens if the homeowner's insurance is less than what the case is worth? Right, so unfortunately, usually you're limited to available insurance in most cases. Now, if the homeowner's, let's say, is 250, but your injury is worth $1 million, you just send them a letter and you say, hey, pay me the 250. Look at all this evidence. Look at my surgeries. Look at my medical diagnosis. Look at my human story, the way I've been impacted, the way my family and my life has been impacted. Pay me the 250. You have 30 days. If you don't, that's fine, but it's not going to be 250 anymore. It's going to be $1 million. And what are you going to do if the jury agrees with me and gives me $1 million? You're $750,000 underwater. Who's going to pay the difference? And if they still don't pay you, then you can make an argument that now it's a bad faith situation, the policy is open, and that the insurance company is liable for the entire verdict because they failed to protect their policyholder when given the clear and unequivocal opportunity to do so, right? That's why I don't call them demand letters, because demand is like, I'm begging, I'm demanding. No, you're giving them the opportunity to settle fairly. And if they don't, then that's bad faith. And there's like a 10-point, usually 10 things you have to do in a letter. I do comprehensive letters, like 15, 20-page letters. There's a lot of different case law out there depending on also on your jurisdiction, like where you are. as to bad faith. Like some places like New York, the bad faith is very weak. Other places like maybe Oregon or Texas or California, they have pretty good bad faith law. So you have to look into that. But yeah, I mean, there are options. But to be honest with you, usually, bad faith is kind of like the exception. So for example, if this was in New York, I would have to tell you, look, it is what it is. You're just stuck with the available insurance. Latoro says, you never marked what things they can't do in the deposition. Thank you. And she's responding to super depositions. Yeah, so I'm not sure what you mean by marked. The way it works is the defense lawyer will ask you two questions, right? Number one, the defense lawyer will ask you, what are some of the things you were able to do before your injury that you were no longer able to do at all? And so it's not a question of marking, it's a question of you answering that based on your life, right? But the lawyer has to prep you. And so, of course, there are many things you could say. You could say, I can't sleep, I can't sit, I can't stand. And you could do a day in the life, meaning think about like the day when you had the most pain after your injury. How did you sleep? Maybe you didn't sleep at all. How did you get up out of bed? How did you put your socks on? How did you go to the shower? How did you go up the stairs, down the stairs? How did you reach up for a cup to make a coffee? Maybe you couldn't, right? Maybe somebody else had to help you because you were so seriously injured. So go through like from when you wake up to when you go to bed, like a day in the life. That's one way to answer the question. Another way is to think about like what's important in your life. Some people play sport, right? Some people play a musical instrument, whatever it is in your life. So you got to make a list. Now I do have a 13-page checklist that I've been emailing to some people who've asked me, and that has a lot of, just kind of has like things that you wouldn't really think of. Like it has things like kneading dough or like, going somewhere for Thanksgiving. And then, if it applies to you, just kind of check that off. But it's not enough to just check off a box on a checklist. What you also have to do is you have to use that kind of like as a jumping off point. So you kind of check the box on the checklist and then you think, oh, what like moment in time can I think of from that? Like when was I kneading dough? Or what moment in time could I think of about this? Like when was I sewing a sweater? Or when was my grandmother sewing a sweater and I was trying to help her, but now I can't, right? Or whatever, if it says Christmas, okay, give me a Christmas memory. And you think of a story and you kind of write that down. And then you can talk about that in the deposition. And then you save most of it for trial. And it's very powerful, right? So that's what you want to do. People think in like stories. Stories are much better than just, reciting things like I can't run, I can't walk. That's just kind of, everyone could say that. So that's the way to do that. And then the second question is, what are some of the things you can still do, but not as well as you could before? And that could be like anything, right? Like sitting, I could sit, but I can't do it as well as I could before because now I'm sitting with pain. So it's like the experience of the activity, right? I could like walk, but I can't walk as far as I did before. Now when I walk, I have pain. So maybe I could even work, but before I worked a full schedule, like, 8 a.m. to like 6 p.m. or whatever. And now I could only work part-time, maybe like 15, 20 hours a week. And when I do work, I'm in pain and I have to take breaks and I just can't, do things the way I used to. So yeah, that's the best way to handle that. And then Nurse Shah, in response to the video, can you guess the TBI, traumatic brain injury, jury verdict or settlement, says it's hard after a year, memories are affected, and this is devastating. Yes, absolutely, you're right. I mean, the TBI, I think, is one of the worst injuries. That's why I get really mad when I have like a TBI case and I'm presenting it, let's say, to a defense attorney, to an insurance company, even to a judge sometimes, and they're telling me ridiculous things like, oh, it's not worth anything, it's worth like $200,000, we don't believe that you even have a TBI because you don't have blood on the brain on a CAT scan. It's like just nonsense, and it just makes me upset. But I'm happy that like last case we were able to get 3.1 million at trial in the settlement, and actually the MRI was normal, and we still were able to prove it, because MRIs are going to be normal because sometimes the brain lesions are just too small to be seen on an MRI. Doesn't mean you don't have an injury. And if they're too small to be seen on an MRI or a magnetic resonance imaging, right, then forget about a CAT scan. There's no way you're going to see anything on a CAT scan unless you have pretty bad blood on the brain, in which case you have a severe TBI if a CAT scan showed anything. The idea that you have to have something on a CAT scan to prove a TBI is like from the 1950s. So I don't even know why people still believe that. But it's kind of sad that people should educate themselves. But, what are you going to do? JPF says, hi, Arkady. If you can post a video on dog bite settlements with nerve damage, that would be great. Delivery driver, thank you. Yeah, that's a good idea. I'll try to do that. I'll run a verdict search, and yeah, we should be able to do that. Now, let me know what type of nerve damage, right? Because nerves are pretty much everywhere in your hands and your feet, all over your body. So it would probably be better if I did one specific to the type of nerve damage you're interested in. But yeah, absolutely. And dog bites, that's just one type of way that somebody, of course, could get injured. So the critical thing there would be like what nerve damage you have, right? Because you'd want to look at past nerve damage verdicts and settlements to get an idea of what those injury cases are going for in your venue. The fact that it's a dog bite, I don't think really affects the amount. You know what I mean? Like as opposed to, like, say, getting rear-ended or having a trip and fall in an unsafe condition. With a dog bite, I believe you just have to prove that the owner, should have restrained the dog, that the dog had vicious propensities. Although now in New York, I believe recently they changed the law on that, and you don't have to prove necessarily that whole, because before they had like this one bite rule that if the dog has like one free bite, meaning like if the dog bites someone for the first time, you can't really sue because the owner would not have had notice that the dog was dangerous. But if the dog did something before, like bit someone or even like gnarled its teeth, showed its teeth, or jumped up on somebody or whatever, did something, they use this phrase vicious propensities, did something vicious, I guess, or something, menacing, then, the owner had notice. So then the owner should have supervised the dog better, restrained the dog. And then if it happens like a second time, then the owner is liable. Although, I think they changed the law on that now. Now it's more like a general negligence standard, just whether the owner used reasonable care. But I have to read that case because it just came out like a few weeks ago. I don't do too many dog bites, although I've done a few. And the ones I've done, they've all settled for pretty good results. We've gotten one, I think was like $350,000, and others for, around that range. So as long as there's insurance, that's the key. Because sometimes, people could be dog owners, they don't have any insurance, then there's nobody to sue. So you need a homeowner with insurance, or apartment, could have insurance too. A Busy says the insurance company is getting screwed at trial, LOL, in response to the video, future spinal fusion costs explained. Oh, I see, that's funny. You're saying the insurance company. Well, no, I don't think I guess, yeah, the insurance company, the thing is that if you have, spinal fusion is a major back surgery. So, you don't want to go in just with pain and suffering, because pain and suffering, depending on your jurisdiction and your jury, some, like I was saying earlier in this video, right? Some juries might give you $5 million for pain and suffering, but other juries might say, hey, it's only worth like $200,000. So another element of damages are your future medical costs. So if you've had a spinal fusion, well, now you're going to need one at the adjacent level. So for example, if you had C4, C5, you're going to need one at C3, you're going to need one at C6, right? At the adjacent levels, the next levels. That's a medically known fact. Now, you might not need it right now, you might need it in 15 years, but it's medically known, right? So why not claim that? That's another $200,000, right? Because each surgery is like $100,000. Plus it's not just the surgery. They don't just go and do the surgery. They have to do physical therapy. They have to do MRIs. They have to do, other visits, maybe pain management. So all that adds up. So, just the future medical costs could be into the millions. So it's important to claim that. Around the Way Tay says, can you sue your landlord for emotional distress? In response to the video, what is the storm in progress rule? I mean, I guess it depends on what it would be for, but usually not. You usually can't sue for emotional distress by itself. I mean, you could sue if the landlord caused some kind of an injury, right? Like say there was a ceiling collapse, and then you had an injury, a physical injury, like you had a need for like a spinal injection in your neck, right? I mean, like a cervical injection in your neck, or need for a surgery, or you had a traumatic brain injury because the ceiling collapsed on your head, and then the traumatic brain injury led to emotional distress like PTSD, and you had treatment with like a psychiatrist, psychologist. You could sue for that. But if you just have like emotional distress, you tell him, hey, fix my, my bathtub is leaking, I don't like it, and he just doesn't fix it. He says, I'll do it, and he never does it, and you just get upset. You can't sue for that. That's, you just move out of there, go find a better place. Okay, Robbie says, how much do you think for 2 major neck surgeries, top of my skull with rods and screws, C2 to T1, fall on the sidewalk, Salvation Army, it's been 2 years, what do you think? I am in Florida. Yeah, I mean, that's a good case. Look, if you have a fall, as long as there's an unsafe condition, you have a defendant like the Salvation Army, find out the primary and the excess umbrella insurance, make sure there's enough insurance. 2 major neck surgeries, from the top of your skull from C2 all the way down to T1, that's a lot of levels because you're talking C2, C3, C4, C5, C6, right? C7, and then I believe, right, it goes to T1. You're talking about 7 levels? 7 levels, that's like your entire neck into your thoracic, because T is thoracic, that's the mid-back. 7 levels have been fused. So you have a major fusion there. You have no mobility there, and you're gonna need also adjacent, segment disease. That's a serious, that could be like, I settled, I think mine was like a 3 or 4 level, and I settled for 3.5 million. So I think that could be like 5 million plus. If it's in the right hands though, remember, you need a good trial lawyer. That's a critical component. Like if somebody who doesn't know how to try a case like that and they have the case just because they put up a lot of billboards or whatever, they did a lot of advertising and you're with one of those guys, they're just going to try to sell it short, just get on the phone. They might get like, I don't know, maybe, I'm hoping they get over 1 million, but who knows, right? The insurance company, if they know the lawyer is not a real trial lawyer, they could say, let's try to get rid of this for 600,000. But in reality, it could be worth 6 million. So in a case like that, you need a good trial lawyer. So Good says, sorry to be off topic, but I'm always noticing that black brace that you're wearing, and I see sometimes you're wearing it at the same time as a watch, and I was curious what that is. Oh yeah, that was like a little one of those fitness things. It's like a Whoop, I think it's called, W-H-O-O-P. It's like a tracker. It tells you how many steps. I actually lost it now, so I don't know. I have to go find it. But yeah, it's not bad. It's just like a little band, and it tells you how many steps you took and some other health information. Okay, and then Joe Phantom says, Arkady's cool. He really tries to help. He tried to help me. For my situation was complex after firing my attorneys from 2 different law firms. The attorneys in my jurisdiction were offended by me firing my former attorneys, even though I had good cause or good reason under the law to fire them, where they received no compensation at all after 2 years. You tried to help me, Arkady, and you gave me great advice. I'm going to use your advice and I'm going to be okay. Thank you very much. Yeah, it's unfortunate. Sometimes people, get in with like bad lawyers and they just, sometimes the lawyers are bad, sometimes it's just not the right fit, right? So the lawyer might not be terrible, but it's just not the right fit for you, right? Because some people prefer to have a smaller firm where, when they call, somebody's gonna answer right away, speak to them. But other firms maybe are big. They might have 500 lawyers. They might have offices everywhere, New York, Florida, California, Kansas, whatever. And they just can't handle that kind of thing. So when you call, you're not gonna get to speak to the attorney, because the attorney is just not available. You're going to speak to a case manager. Case manager doesn't know anything about the case, really. They're just going to give you, generalities like your case is in court, and you don't want that. You want more. So, you have to have the right fit. That's important. So it's good to do your due diligence before you hire an attorney and make sure you have the right fit. But the most important thing, I think, is that they are a real trial attorney, that they're willing to go to court, that they're not afraid. They're not going to tell you, oh, if I go to court, I'm going to get nothing. You better take 30,000 and kind of force you to settle, because then it's like, what's the point of that? You need somebody who's fearless and is going to go to court. As long as the case is good and the case can be won. Of course, some cases, it's better to settle because there's some issues that, if you go to court, you could lose, and then it just doesn't make sense, right? You have to always weigh all the factors and be smart about it. And then Jonali says, hi, as a personal injury lawyer, do you think it's possible to put advertisements about your legal services inside a clinic? Yeah, so if it's a medical clinic, I'd probably say no, because it's probably not allowed by the ethical rules. But you are allowed, they are allowed to refer patients to you. So if you know somebody at a clinic and they want to refer patients to you as an attorney, they're allowed to do that as long as you're not paying per referral. That's also unethical. But yeah, so they could refer to you. They could give the client, let's say, options, attorney A, attorney B, attorney C, and then the client could choose, or they could say, hey, we like attorney A, and just not give any other options. I think both are allowed. So you could maybe speak to them that way, but I don't think you could put like a sign right in the clinic. Hey, yeah, that would probably be unethical. Arg says, in New York, a 4 herniated disc case from a rear end by 18-wheeler with physical therapy and pain management, but no epidural injection. How much is it worth? Average for those cases. So you're talking about 4 herniated discs and you got rear-ended by an 18-wheeler. So yeah, I mean, if you have 4 herniated discs and the doctors say that these herniated discs are from trauma, meaning from the crash, it could be, it could be worth a lot. It could be worth like 100,000, just, off the top of my head, 150. The fact that you got hit by an 18-wheeler, you'd have to find out how much insurance they have. Usually they have at least 750, but a lot of times more. If it's a company with many trucks, they might have $1 million with like 5 million excess or even more than that. So physical therapy, pain management, but you said no epidural. So what type of pain management did you do, right? Because usually when you say pain management, in my mind, epidurals are like one form of pain management. Another one is a percutaneous discectomy. I mean, there's other procedures like radiofrequency ablation. But if you just say pain management without telling me what you actually did do, it's too general for me to tell you. You know what I mean? But yeah, you could also text me or just let me know, and I'm happy to chat and answer your question. Ace Boggy says, literally what it feels like is happening in my case in response to the video from a strong case to a small check. And he's saying that he's on his 3rd lawyer. The 2nd one became a judge, so handed my case off to his partner who hasn't done anything to help him. And he just said there's a meeting in July to determine if the amount they offered was reasonable, and it wasn't. How can a judge determine that, and not knowing the majority of the pain and suffering this case has caused me? I lost a longtime partner, my job, my friends, some of my family, and now I have a fractured relationships, and this whole system takes advantage of people who aren't well off. Even the Lao who are supposed to be working for you aren't forthcoming. Oh, the lawyers, I guess. Yeah, no, I'm sorry that that's happening. I mean, but definitely the system does need a lot of fixing for sure. It's very slow. Like, for example, the case I just finished, right, for 3.1 million, that lady fell in like, what was it, September 3rd of 2018, right? That's been like almost crazy amount of time. So it's like people are waiting for like 10 years sometimes. It's really, and there's not really any good reason for it. I don't really understand, because like, you don't need 10 years for this. You just file the lawsuit, you answer within 30 days, do your depositions. You can do depositions, take a few hours, exchange your papers, put it on the trial calendar. I mean, I understand like you can't do everything all at once. You have a busy schedule. Okay, give you a year to do discovery and then maybe another year on the trial calendar, but that's like 2 years, not 10, right? It's just like it doesn't make any sense. It's just like very bureaucratic and it doesn't work. Yeah, they have to fix the system. And Anjanya says, I got a sua sponte non-binding arbitration order. What does it mean, good or bad? Does it mean they want to settle? What caused it to happen? So yeah, sua sponte just means the court just does it on its own. And non-binding means you can still go to a jury trial if you don't like the arbitration amount. So you have the arbitration, let's say the arbitrator gives you, I don't know, $1 million. You want that, you like that, you take it, right? And then you get it. But if the arbitrator says, oh, it's only worth 10,000, you could say, it's non-binding, I don't agree, I still want a jury trial. So I think it's generally good. I don't see why it would be bad. You don't really lose anything. Ubunt says, defense wants to download the black box data from my rear-ended car. How effective is this strategy for the defense? Do they want to impeach the plaintiff on if they were wearing their seatbelt to minimize injuries, or is it just a defense lawyer billable hours? How does a jury respond to this tactic? I mean, look, if you got rear-ended, I mean, unless like you stop short right before the impact, I don't think the black box is going to really help them. So it's okay to give it to them. Also, you can just file a motion for summary judgment. Once you get judgment as a matter of law, then all that stuff is going to be irrelevant because you have the judgment. It's going to turn to damages only. And plus you get interest from the date of the summary judgment motion decision, which could be like for example, if I have a case now, I file a summary judgment, I can get a decision in like a few weeks, but the trial might not be until 2027, 2028, but then interest runs back to when I got the decision now, right, in July of 2025. So it's good for you because you adding 9% interest to the ultimate amount. But yeah, I don't think a black box, I mean, if I were you, I would get the black box from the car that rear-ended you, and I would show that to your expert. That's important. But from a rear-ended, if you got rear-ended, I mean, unless like you stop short, like right for no reason, right before the impact, then maybe the black box would show, that the speed went from like 40 to 10 in like less than a second. That could be a defense. But other than that, I can't think of anything. It wouldn't really, I don't think a black box would show whether you're wearing a seatbelt or, so it wouldn't really matter. Orange says, Mr. Frecht, have you ever had a client that had a blank slate, no friends, no family or much family, or a scenario where you could paint a picture and create a story from. And he's responding to the raw law. I mean, usually everybody has a story, just sometimes you have to dig a little deeper to find someone's story. So for example, like one lawyer was telling the story of a husband and there was a wrongful death, right? So the wife died because of a wrongful death crash, and he never really told the lawyer anything, and he didn't really have any story, and he was just kind of quiet. But then when the lawyer went to his home, he saw that this husband would always like look at a picture of his wife on the wall and kind of blow a kiss to his late wife. So then the lawyer made that the story, right? The lawyer came up with a story about that. So you could always create a story. Sometimes you have to dig a little deeper and find the story. That's kind of the lawyer's job, to find the story. Thank you, everyone. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. All the best. Bye-bye.